First case on our docket this morning is 22-10271, United States of America versus, I think it's pronounced Reagor. If it's not, please correct me.
It's Reagor.
Reagor. Thank you. Mr. Markham.
I believe I requested 5 minutes to be reserved for rebuttal. May that be allowed?
Yes.
Thank you. May it please the court, and thank you for hearing us. The issue in this case is the state of mind of the defendant when he asked for working capital. Not the bank's state of mind, the case is made clear. Not what the bank understood, but what he understood. He thought that what he said was accurately what he meant. It is not a crime under 1014. If I could, I'd like to start with a hypothetical, very brief one to make my point. If I go to a bank, say in a part of the United States that suffers tornadoes, and I say, I want a large loan because I want to build a stone house to be protected for tornadoes. And then I get the money, and I've intended all along to buy cheap plywood and build a house. Plywood is not stone. Everybody knows that. However, Your Honors, not everyone knows what working capital means. The proof of that is that during this trial, 4 different highly qualified experts testified without objection, without any Daubert hearings. 2 for the defense, 2 for the government. The government's experts said working capital means you cannot use the money for distributions, as Bart Reagor did. 2 of the experts said, why, yes, you can. That's the only place you can take distributions from. The definition of working capital means any legitimate purpose of the business.
If you had experts on both sides and, differences of thoughts, why isn't that a fact issue? Why does that elevate any greater than what juries determine? I mean, this was a jury trial. Why isn't that permissible for the jury to parse it all out and come to a conclusion?
Your Honor, the issue in the case was not what the proper definition of working capital is. The definition was Bart Reagor's state of mind when he said, I want working capital.
Well, I mean, I get that, but you don't deny that what is working capital, that's a fact determination, do you?
No, Your Honor, it wasn't, because the definition of working capital wasn't on trial. What it was
what is working capital allows one to determine state of mind of the defendant, doesn't it?
Not unless he knows it. Your Honor, there are things that you and I learned in law school. I could say res ipsa loquitur to you, and you would know exactly what that meant. But if I were to say res ipsa loquitur to my young son, he'd say, what are you talking about? That's not the issue. The issue is what he meant when he said working capital.
I understand it's what he meant, but how is the jury otherwise to determine? They can't get in his head. So what is it you say the jury would be permitted to do in order to determine the state of mind?
Well, one thing, Your Honor, that was front and center at the trial was 2 things, actually. One was that the bank, when it was drafting up the loan documents to send to the lender, the bank put in a provision, section 7.2 of the loan document, this is all in the record, and sent that to Mr. Reagor and his lawyers. And that document, Your Honor, the initial draft, had a definition, said you are not allowed to take distributions from this working capital to pay owner distributions. Said it. Mr. Reagor's counsel came back and said, wait a minute. Well, now we stopped doing that for a while, but we're intending to start again with the distributions. The bank then changed the document so that it no longer prohibited distributions. What it said was, you're not allowed to take distributions of any kind without mentioning distributions to partners if it renders the company insolvent, which is very different. So it seems to me that the evidence of his state of mind is smack dab presented by the fact that they asked for a change and the bank went along with it. And so I respectfully submit that if you're sitting back there and the jury's sitting back there saying, did he lie? Well, if he had been borrowing money to build a stone house and he bought plywood, everybody knows the difference between those two, Your Honor. I respectfully submit.
What do you do with his email? You know, he's saying he doesn't want anybody to know about it. It's all between us, you know, et cetera. The jury's supposed to ignore that?
No, Your Honor, I don't think they're supposed to ignore it. But I think that there is two points I'd make with that. The first point is that businesses routinely keep matters secret from everybody. And he said everybody, not just the banks. But number two, if he had thought that was a secret just from this bank, not just the banks, but just from this bank, and why would they have insisted that the loan document, the written document, the unarguable document that said no distributions allowed to partners, and that's changed to something very different at their request. And they made it clear they were going to take owner distributions. So I respectfully submit that with respect to that, Your Honor, there is inadequate evidence that he intended to, when he said working capital. And again, I stress that I'm not saying we won the battle of what working capital is. I'm saying that working capital is not like stone. It doesn't have a clear understanding. The example I used in my brief was that if somebody comes and says, I want to borrow money to build a house, I've got 20 acres of land with a lot of the land on the beautiful Mississippi River, so it's a great valuable piece of land. I got 20 acres. If I have 4 acres, everybody knows the difference between 4 and 20. But not everybody knows what working capital is. I would warrant that if you were to ask the average lawyer what working capital means, or judges, they'd have to look it up, they'd have to parse it carefully, and they'd see that there's a difference. Now, the GATT regulations, the normal accounting regulations, showed at trial that they believe that working capital includes distributions because you pay people what you owe them for their work, whether it's a partner or a receptionist or anybody in between, you pay them from working capital. You can't pay them from anything else. And so I respectfully submit that there is no evidence of state of mind. I would like to address a couple of other things which are in the government's brief. The government cited, Your Honors, that what the government told you in its brief to you and told the jury in its closing argument, that what Reagor had said was that he wanted working capital, the entirety, their words, of which was to be used for beefing up the subsidiary car dealerships. The word entirety was never uttered by Mr. Reagor. We cited the statement that the bank president made when he was asked by the government at trial in a non-leading question, what was it that Mr. Reagor said to you? Mr. Reagor did not say the entirety was going to be used. What he said was, we need working capital for our business. That's a very different statement. They did not prove that by that he knew he couldn't use it for distributions. And where the entirety word came from is significant. The testimony was that the bank officers came out to meet with Reagor and some of his staff and said, okay, we see your operation, all looks good, what are you going to use this money for? And he said, working capital. They went back and wrote a memo to the bank lending committee saying, well, he wants working capital, the entirety of which is going to be used for the business. Now, if Reagor had said the entirety of this is going to be used for the business, we wouldn't be here because that's clear. That's the difference between stone and plywood. That's clear. But he didn't say it. The internal bank memorandum said it. And at trial...
But why isn't there a difference in the fact that when the money came in, he immediately moved it to his personal account in a different bank, rather than money comes in here and then it's kind of going around and then a little bit goes to him and, you know, whatever. He's clearly getting this money to put in his account, a portion of it, and not just normal working life of working capital where things get somebody gets a salary, somebody gets a this, the partner gets some amount, and so on and so forth. He's immediately scooping into his bucket. Why doesn't that also, together with his thing about, keep it confidential, don't tell the bankers, why doesn't that at least give some evidence for the jury to consider?
Because if the government must prove beyond a reasonable doubt that he lied to the bank, if they did not prove that he did not understand that working capital, you can't take it, they had to prove his state of mind about the bank's state of mind. I want money for working capital. If they both understood that to mean that he can't use it to pay distributions, then he's lying because he understood it. But if he didn't understand it, I respectfully submit it doesn't matter whether he...
As Judge Stewart said, so you can't tell exactly what I'm thinking about your ability to argue, and so your only way of inferring that is some of my questions, maybe if I was making a face, maybe if I was smiling, maybe if I was groaning. I mean, but you might be completely wrong. Maybe I have a completely different thought than you're thinking. Maybe I'm thinking about the light back there or something. You don't know what I'm thinking or anybody else is thinking, but you infer that from all kinds of evidence. And that is exactly what happened here, right?
Well, he did take it right away. You're right about that. But if the government didn't prove that he knew doing so was violating his word to the bank, then when he took it is not relevant. Because he took it, he thought he could take it. They didn't disprove that. It's the burden's on them. And you're right, the state of mind is a difficult thing to prove, and you can do it by inferences. What about the bank loan agreement that said, get rid of that loan distribution prohibition? What's that? That's not an inference. That's not you grimacing at, Your Honor, grimacing at my questions, which I don't think you've been doing, I hope. So that's the difference. So, and when they were in the courtroom, and the government had presented this business about the entirety of the bank loan would be used only for working capital and not to pay distributions, counsel for the defense asked the banker, well, wait a minute, that's a bank internal memorandum. That was never shown to Reagor. And entirety, he's not bound by that. And the bank said, yes, he's not bound by that. He's not bound by Exhibit 4, which was the bank loan memorandum. He's bound by Exhibit 2, which was the loan agreement. And the banker said that. And that loan agreement, as a matter of contract law, evidenced the state of mind that hopefully has Your Honor smiling rather than grimacing, because it says, we can't do it that way. We want to take distributions.
I'm still trying to understand. You're obviously not arguing that working capital and all the rest of this is incomprehensible to a jury, right?
They were never given I don't know. They were never given an instruction on what working capital is.
Well, they weren't, but we don't have in this case an issue about an incorrect jury charge or not, right?
We do not.
All right, so you're not challenging the way the evidence was funneled to the jury.
No, I'm not.
All right, the experts, without objection, testify for both sides, right? So the jury has the full case, all the charges, all the evidence to sift through, all your arguments or the trial counsel's. They sift through, they got an Allen charge here, and they make a decision. So where's the legal error? I know you're arguing insufficiency of the evidence, but where does it go off the rail? What did the jury impermissibly do?
They impermissibly came to the conclusion that Reagor knew that working capital meant distributions. And may I follow up on that?
Sure.
This is obviously the focus of Your Honor, and it's a good focus. I can't argue with it. Let's suppose that there had been no experts for the defendants. Let's suppose that the defense counsel stipulated with the government counsel at the beginning of the trial that working capital meant you cannot take distributions. That doesn't end the matter. The matter is what Reagor thought. It's a state of mind crime. Look, I was a prosecutor and prosecuted fraud cases for a long time. It's nettlesome to prove the state of mind of the other person, but Congress has made state of mind a valid...
That's true, but what is different here? Juries get patent cases, they get super duper complex issues. lay people, they get instructed, they stay out, they come back, they make decisions. So here you got a full-blown jury trial. I'm sure extremely able lawyers on both sides. They heard the same arguments. I'm just like, how does the panel here say it's totally implausible, what the jury found here in a jury case? I mean, you acknowledge that. I mean, I hear you. I'm just haven't heard you say, what did the jury do that was so impermissible that we would reverse it? That's different than anybody who loses disagreeing with what the jury found. I know it's a red light, but you can respond.
All right. Thank you very much for the time. You can take it off my 5 minutes. I think the answer to that, Your Honor, is that if you look at what the government argued to the jury, it argued to the jury that the statement by the defendant was that the entirety was going to go to the company and nowhere else. That was not true. And I would close on this. Why is it that the government made that stretch? There is nothing in this record, and I invite them when they get up here to show to the contrary to this statement, nothing in this record that would show that Reagor said the entirety would go to working capital.
Did you make an objection? Or did the defense counsel make an objection to misstatement of the record?
I was not there, Your Honor, but I read the record pretty carefully. I don't think that he did. But the question is this. It's not that it was improper to do so, but why did they stretch it? I think they knew that on the basis of what Mr. Reagor said, they were going to have a hard time proving the 1014 state of mind. Thank you for the extra time, and thank you for hearing me.
Good morning, Your Honors. May it please the Court. Amy Burch for the United States. This Court's precedent about the weight and the deference afforded to jury verdicts, along with the evidence presented at trial and all reasonable inferences drawn therefrom, when viewed in the light most favorable to the verdict, compel affirmance here. The trial evidence told the story, and it was a story of two Bart Reagors. The first Bart Reagor is the one that met with the IBC executives on April the 4th of 2017. The best evidence of what happened at that meeting comes from two sources: the people who were at the meeting and the internal commercial loan memorandum that was prepared days after that meeting. The first group of evidence, the people who were at that meeting, that was IBC Bank President Bill Schonecker, that was another IBC executive who was the loan officer on this loan, Will Woodring, and that was CFO Shane Smith. Those people were at the meeting, and their testimony taken together allows the jury to draw the inference that Mr. Reagor knew what working capital was. He knew and represented to them that he needed this money for the business to keep his business operating because it had grown at exponential leaps and bounds, and he needed the money because he had these big visions about what he wanted for the RDAG. He wanted it to be the biggest, baddest dealership in America, and in 18 to 24 months, he wanted it to go public. That's what he told them. He also told them, importantly, that they had stopped taking owner distributions as of March of 2017. We also know that Mr. Reagor knew what working capital was because his own CPA, defense witness Chuck Darter, testified that he had sat down with Mr. Reagor and Mr. Smith and talked about, hey, we got to slow down these owner distributions because you're taking too much money out of the company. You've got to leave money in the company. So Mr. Reagor certainly knew that he needed to leave this money in the company, and that's what he told the IBC executives.
That seems to me a little bit different to say no distributions versus slow down. Were they permitted to take distributions under the loan agreements?
Your Honor, the testimony from the IBC lawyer, his name was Thomas Hutchison, he testified that that loan agreement would not have allowed distributions if it caused an event of default. And his testimony was that using the loan money for a purpose other than working capital would have caused an event of default, and thus distributions would not have been permitted without the permission of the bank. So they could have gone to the bank and said, hey, we'd like to take an owner distribution. And the bank could have considered that. But at no point in all of these discussions in April did Mr. Reagor tell IBC Bank, hey, we're going to get a $10 million working capital loan, and then immediately on the very same day that that money hits, I'm going to take $3 million of that and divide it, or it actually came in two groups. So the first group would have been, he would have taken a $766,000 distribution. I'd also...
So what is your response to his argument about this section 7.12 change from saying that that's not allowed to taking that out? What is your response to that argument?
Yes. The initial 7.12 said that it would allow the owners to take distributions for taxes. That was eliminated, and now it's just left with you can take a distribution as long as it doesn't cause an event of default. But the testimony that the jury heard was that using the money for something other than working capital would have caused an event of default. And they were free to credit that testimony and weigh it out along with all of the other testimony they heard. But, Your Honor, I'd like to also point out that...
So are you saying the issue in front of the jury was whether at the time Reagor took the distributions, he believed that it would create an event of default?
No, Your Honor. No, Your Honor. We believe that the issue in front of the jury was whether Reagor knew at the time that he made these representations that they were false, that he told the bank, I'm going to use this money for working capital, and working capital is I'm leaving this money in the company to run the company, when that was never his intent, as evidenced by his email.
The agreement did not mirror those representations, and why doesn't the written agreement govern? In other words, he wasn't required, the documents allowed him to take distributions. So I don't see how the actual document doesn't govern over prior representations.
Your Honor, first of all, we never even get to a loan agreement if he tells the truth on April the 4th of 2017, hey bank, I'd like a $10 million working capital loan. I'd like to use $7 million of it to run my company, and I'd like to siphon off $3 million to pay my partner and myself in the way of an owner distribution. Instead, what he tells them is, I'm going to use this money to run the business, and I've stopped taking owner distributions. Now, secondly, the government takes issue with whether this was even an owner distribution. I mean, Mr. Darter, the CPA, told the jury that the partners had been taking owner distributions at a rate of 40% out of the profits of the company. And the working memorandum, or the loan memorandum, indicated that the partners had told IBC Bank that they would stop taking distributions for a savings of $90,000 a month. But if you look at those two things together, this immediate diversion of the loan proceeds, it doesn't match up. It's not. It was, for at least for Mr. Reagor, it was immediately $766,000, which is way more than the $45,000, even if you would consider that a distribution. And second of all, with that second tranche, it was a $1 million distribution.
Well, so are you making the analogy to like a law firm where if you're an associate there, you're going to get the salary that you're supposed to get, but if you're an equity partner and the firm is losing money, you ain't going to get anything, or you're going to get a lot less than you had thought you would.
Right, Your Honor. So
you get a percentage of the profits as an equity partner.
And typically you would see an owner distribution coming out when the owners have said, hey, we're going to take an owner distribution. It's going to be this amount of profit or whatever. What his email...
It's not a secret usually.
Right. And what his email was, it didn't say, hey, we're doing really well, blah, blah. What it said was, and I think what the jury could easily infer, and what this court must assume is the inference, is in this email he says, hey, every dollar we borrow, we're going to take 33.33%. That's not even limited to the IBC loan. There are other loans listed in that email where he says every dollar we borrow, and he says we're doing it to protect ourselves, to protect what we've done, to pay ourselves back, which is also interesting because Shane Smith testified that they had, in March of 2017, Mr. Reagor had made a $500,000 deposit into the company to cover the losses from this bad audit that they had. But he's immediately going to pay himself back with $1.7 million for the $500,000 he supposedly borrowed. But also in this email, there are other inferences to be drawn. First of all, the super secret nature of it.
Well, I'm going to get back to my basic question. To succeed that this was something criminal, you had to show that not only that the document didn't permit it. And so it seems to me you had to prove to the jury that at the time he took the distributions, he had reason to think this would put the company into insolvency. Isn't that what you had to prove? And it seems like you've got plenty of evidence to that effect.
We had to prove, and I want to make sure I heard you right, we had to prove that he intended to mislead the bank to cause them to issue this loan. And that is what the government...
But he did it with the intent of understanding that he could take distributions as long as it didn't cause the company to go in default, right?
Well, that is what the testimony showed. I'm not sure that that's what the government necessarily had to prove. I think the government necessarily...
Assuming you had to prove that, there's evidence that supports that.
Yes, assuming that we did have to prove that, there was testimony to that effect, and that testimony came from Thomas Hutchison and others. Yes. Your Honor, the jury was also free to use their reason and their common sense and the things that they know in the light of everyday experience to understand that if someone tells you that something has to be kept 100,000,000% confidential and not to tell the bankers or anyone else, they are free to infer guilty knowledge from that. They don't have to infer guilty knowledge from that, but they are free to. And this court must draw the inferences in light of the jury verdict. And so we would submit to the court that Government Exhibit 41, which interestingly, the timeline tells the story here too, because we have that.
Well, and the other things he said about kind of like he's charging his life to, these, whether it's at OPMs or something like that, these other people.
Yes.
So it's not just, obviously confidentiality alone is not unethical. We're going to go have a conference after this, and we aren't going to tell you what we said at the conference. I don't think that's unethical, but that's a little different from don't tell the bankers that I'm taking their money.
Absolutely, Your Honor. And the jury did hear the video that you referenced, Government Exhibit 48, which is the OPM video. And he specifically says in that video, this is how I do it. You take other people's money, you talk them into giving you money, you use their money to increase your net worth, and most people don't have any idea of the expletive I've pulled off in my lifetime. That's what he says in the video. And the jury is free to take that and say, yeah, we have some idea of what you've pulled off. We do, and they did here. The government also presented evidence in, it was an audio exhibit 51, and it related to the motive of Mr. Reagor, and specifically, Mr. Reagor is a larger-than-life character. He's loud, he's braggadocious, he's all the things. That's not a crime. But what he did say in this video is, hey, I've got planes, I've got a house, I've got a mansion on 19th Street. There's, you have to have what I have, basically, to be a winner is kind of his mentality. I don't think he used the word winner in
Stealing
there.
it from the bank, he can have a better rich life is what you're saying he was implying.
It was really important to him to not only be successful, but look successful. And so when he says these things, the jury was free to take that and say, look, there's a reason that he didn't leave the money where it was supposed to, even though his own CPA and his own CFO told him to. He didn't told him that was important. I'm not going to say they told him that specific to this loan, but they had told him before, that's what you need to do. And he just couldn't do it. And Your Honors, the evidence here, all of which the jury had before it, what the loan agreement would and wouldn't allow, what he said or didn't say at that April meeting.
I mean, is that why his dealership ultimately failed, was because he was taking too much money from it?
Your Honor, there were two things related to his dealership. There was a very, very large scale, two very large scale frauds going on, a floor plan fraud and a check kiting fraud. Ultimately, at sentencing, the district court did not hold him responsible for those two frauds. And then the second part of that, which the district court did talk about at sentencing, was why are those frauds being perpetuated? Because, Mr. Reagor, you ran your company in a way where nobody could tell you bad news, where nobody could come in and say, hey, don't do this. And so because he was taking so much money out of the company even before the bad audits, and then he takes money here, and then the floor plan totally falls through when Ford Motor Credit comes in and calls the loans due. And I'm sure the court has seen multiple of those other cases coming through this court.
My point was, you earlier pointed out that he was taking so much money in general, and that does cause problems with companies.
So it was twofold. It was the amount of money he's taking out, but there was also this other massive.
I understand about the frauds. Yeah. Okay.
Yes. If the court has no other questions, we would ask the court to affirm the jury's verdict and render this case finally, and we thank you for your time.
Ma'am. This court can read through the closing argument 10 times. It will not find the argument that Mr. Reagor rendered this company insolvent by what he did. It was not the issue. The issue, as the judge described it in his in limine motion, was whether or not Mr. Reagor knew, when he told them he wanted working capital, that he was deceiving.
But if that is evidence that needed to be there and it's there, whether people give a good closing argument or not is not, in my opinion, the basis for determining whether there's sufficiency of evidence.
It just wasn't what was argued in the closing, Your Honor, and I cited in my brief. What was argued was...
Right, I understand that, but what I'm saying is, while you can appeal an improper closing argument, I've never heard that a not good closing argument means that the defendant has to prevail. The question is sufficiency of the evidence, not ability of the lawyer to make good closing arguments.
Well, that's true, and I would suggest that there was no evidence that there was insolvency precipitated by what he did, and it wasn't argued, and I submit it wasn't argued not because the lawyers below were not able. They were. They were very good on both sides, as Your Honor pointed out. What it was they knew that wasn't the issue. They didn't argue it because it wasn't about Mr. Reagor knowing that he was about to make the firm insolvent and knowing about the loan agreement. That wasn't the issue. I've repeated what the issue is, and I stand on that. The counsel for the government made the reference that to the fact that the bank memo was a reflection of what happened in that meeting. The prosecutor asked the president who was at that meeting what Mr. Reagor said, and he did not say that it was the entirety of the loan that was going to go to working capital. He did not say that. Question, he was asked about that bank memorandum by defense counsel. The president of the bank was, Mr. Reagor is not bound by Exhibit 4. Mr. Reagor is bound by Exhibit 2. Answer, correct. That's the bank's musings about what working capital meant, and the Fifth Circuit has said it is not the state of mind of the bank, it's the state of mind of the person charged with the offense, knowingly to make a false statement. And since we're talking about the bank being bound by two, as well as him, Your Honor's point about what the bank said in its own memorandum, it did not exclude working capital. And you don't punish somebody for being improvident. You don't punish somebody for being braggadocio. You can be a jerk. You can go home and kick your dog. You can do all kinds of vile things, but it's not evidence of your state of mind on a bank loan. And yes, Mr. Reagor was quite the braggadocio. He was quite the puffer. As the court said in its findings, he was quite the braggadocio, but he was also very generous. He had the court filled with people who supported him. I can't argue that for the purpose that he didn't know. They can't argue that he was basically an over-the-top person. And the fact that he's bragging about his house doesn't mean that he thought he knew he couldn't take the money when he told the bank. Defense counsel, government counsel said it, I think, best. The question here is what he knew when he told the bank he wanted working capital. That's what it is, not insolvency. How could he predict insolvency a year and a half later? That's just not the issue. And they never argued it. Your Honor, throughout our society, banks live and die by their agreements. You come home with a new car and all of a sudden you find out, well, the small print here means this and the small print here means that. They do. And that agreement was changed to reflect the intention to take working capital. It's just not a 1014 crime, Your Honor, to take more than you should have. It just isn't. That's not what the bank loan agreements do. People borrow money all the time and businesses collapse. Sometimes they collapse, like in that big blood trial we had out west where the woman was saying this blood test could do everything and she knew it couldn't do everything. And she got lots of money that way. That's not what happened here. What happened here was assuming working capital means you can't take this for distributions. I respectfully submit they didn't prove that he knew that. And as one of your honors said, confidentiality is routine in businesses. And one last thing, the government suggested that it was Mr. Reagor's over-the-top attitude that made these employees do these horrible scandals they did. That's what brought the company down. That's not a crime. And by the way, the government prosecuted each and every one of them and didn't prosecute Mr. Reagor. So he can't be blamed for that. And that's what rendered the company insolvent. Thank you very much, Your Honor.